Hello, anybody that's out there. It's 7:30 on Monday, the 23rd of June, 2025, and it's the Social Welfare Law live stream. So far, it's myself, Karis, and Mike, and hopefully Shannon might be joining us, but she hasn't done yet, so we'll just press on. Now, for anyone that struggled through the last meeting from last week, apologies for the appalling sound quality. I hope that's not a problem now because I think I figured out the answer was I didn't have headphones on, so the sound was going in through my mic and then back out again. Um, and also, I hope that I felt the subject matter didn't turn out to be quite as interesting as I thought. I thought it sounded a bit like whiny, so I'm sorry about that. But hopefully today would just be more sort of rather than saying oh why is the world so terrible and all that. We'll just concentrate on some new law reports, some cases. These are from my law database, which you can access via the resources part of my blog. I'll just show you where that is. WFLAG blog. So if you go into here, I can show you. You go into resources, and
Will, your screen's not shared at the moment.
oh,
So you
sorry.
can't see what you're seeing.
Thank you very much. I shall now share it. So you should now be able to see my blog. So that's you just type wflack.com or do William Flack blog and it will Google bring it up. So then you go into here and you've got the main page, sorry, here, which was visit the site. Sorry, there we go. That's the front page, which isn't terribly exciting. It's last week's live stream. But you go over to resources, and then what you've got over here is the case law database, and then there's the list we always talk about of. I know, God, why is first odd? It's not on here. I'll have to. I thought that the list of solicitors who you could find was on here. So I'll put that back up. But anyway, if we go back to here, it should take us back. So this is the one where you've got all the different reports in here. But if you just want to see the ones that have been added in the last week, there's a tab over here where you can do that. And so without going into more technical stuff about how the database works, what I've got in this week's one, you may say, hang on, that's from 2009. So that's not a new case. It's just one that I've added because I heard about it. So sometimes if I'm reading a modern law report, I might see a reference to an old one and think, oh, that should be in there too. And then just to remind you, you can get a pattern. So if you want to see like all the cases, forgive me if I'm going into too much detail, but it is quite good, this. I noticed it. You go to, if you want to just see all the cases about suitability of accommodation, those cases are all cases about suitability. And then if you want to do, I think there's other tags. There's one for housing needs assessment. Yeah. Oh, there are more than those. So maybe they're not actually. Oh, actually, they're not all. Yeah, I think the other ones, which is High Court. So these are actually all the main courses on cases on housing needs assessments. And as you can see, it's been a bit quiet the last couple of years because there was a little flurry of cases 2 or 3 years ago. And there's this new one. So maybe I'll start off talking about that, which is Norton v. Haringey #2. And what's going on in there is quite nicely summarized. In fact, both of the barristers on the cases have written their own. Oh, actually, there it is. Sorry, if you want to see Stephen Evans's account, he was the one who attended for the council successfully. But I've heard that he was told actually he didn't have to get up because the Court of Appeal had made their mind up straight away without hearing representations from the other side. I may be wrong about that, but he's an experienced barrister, so if he had stood up, I'm sure it would have been interesting to hear. But here's his account. But if I go back to Lindsay Johnson's summary, this does show the sort of slight craziness of where we're at with suitability, because he calls this nuts and bolts on a bumpy roadmap to suitable accommodation. And the reference to nuts and bolts, which you may know, is something one of the judges said in one of the earlier cases, that a housing needs assessment should set out the nuts and bolts of somebody's situation. So what Lindsay Johnson was arguing here was that if you haven't done a housing needs assessment, then any offer of accommodation is going to be unlawful because you haven't considered what the person's needs are. And this is described as an issue of hard law. So it's not really the facts, it's just saying that's got to be what it is. But unfortunately, the court found against him, and they set out three main reasons, which are actually quite compelling. So if you think about it, the argument here is you've got to do a housing needs assessment. You've got to consider how someone became homeless, what would be suitable for them, and what support they'd need. And until you've done that, the argument is you can't make a valid offer of accommodation. But it all gets a bit like sort of Dungeons and Dragons and rules, but which don't seem relevant but do make sense. But the point they made was if you get section, of course, the housing needs assessment. We're talking about section 193 offers here, where they've actually accepted a duty. Yeah. So one of the reasons the court said that a valid housing needs assessment isn't a prerequisite is because they can make offers of accommodation under section 188 and consider suitability long before a housing needs assessment's been completed, because that has to be provided right at the beginning. So it did raise an interesting legal question, but probably only really interesting to lawyers, which is if you get a rule which you get in homelessness legislation that says something like the local authority shall do this. The question is, what happens if they don't? Does that mean that everything that they do afterwards is invalid, or does it just mean that they're open to criticism? And the answer is the second one. They're just open to criticism unless the Parliament phrases it such as, for instance, you can't complete a Section 202 review lawfully unless you've got the prescribed information about a Section 204 appeal in there at the end. And I think it's worded, I haven't got it in front of me, but if you look at the wording, it says it won't be valid without that. And one of the things they said here is Parliament could have done that here. They could have said, you've got to do a Section 189A assessment, and if you don't, you can't make a valid offer of accommodation. But there's a couple of reasons they didn't do that. Number one, it would slow up it would mess up everything if every time somebody forgot to do a housing needs assessment, an offer was made which was invalid. And then what happens if the offer gets accepted? Do the council withdraw the offer and say, sorry, we couldn't, that was an unlawful offer? But it begs the question of why did they bother bringing in this requirement? I mean, it's part of the problem is that it's just bad drafting of the legislation, and they didn't really want to be too tough on local authorities. But then you think, well, why do you say you've got to do all this assessment stuff? And if it's not necessary, and you can make a perfectly valid offer without doing it. And the answer is, I guess they were trying to push things in the right direction, but didn't feel that they could grasp the thing. And I think that it shows the reality that Parliament knows that local authorities just don't have the resources or the means to do the things that they want them to do. And so they word it in such a way that they can wriggle out of it. The good news is that Lindsay Johnson, having shown his determination before, this is the second time he's taken Mr. Norton's case to the Court of Appeal. He went there earlier where he said, when they did the suitability review before, it was prepared. So he had to go to the Court of Appeal. Why did he? Oh, yes. I've forgotten why he went there before. It says here, actually. Yes, it says Mr. Norton was offered accommodation by way of a private rented sector offer. He requested two reviews, the first against the decision that it was a private rented sector offer, and the second against the suitability of the accommodation. And then he went to the court, all the way to Court of Appeal, where they found that it wasn't a private rented sector offer. I haven't got my head around that. I'm going to have to read that because I wouldn't have. I've forgotten what it has to be. Are there qualifying things that something has to be in order to be a valid private sector offer?
It's got to be a 12-month tenancy, and it's got to
Okay.
meet. I mean, I think it basically has an enhanced level of standards, like rather than. But again, it's a bit murky with that in terms of what it's all in Chapter 16 the Code of Guidance is a mess. So, but I think it's certainly got to be 12-month tenancy, and also I don't know if it'd be relevant, but the fact is that I think that they have, like applicants have to be told that if they become homeless unintentionally within 2 years, then they don't have to satisfy the priority need requirements the second time. They just automatically be in priority need. I don't know. I'm not sure if that's that has to be part and parcel of
Oh, that's
the offer. I'm not sure.
yeah, but it seems a bit crazy that you would be arguing about whether it was a private rented sector offer. I mean, call me thick, but I'd have thought if it's in the private rented sector and it's offered, then it's a private rented sector offer. The question is whether it's suitable or valid, and if it doesn't meet the other requirements, I'd have thought that's important. But it just means this whole thing is is just so complicated now. And I'll come back to more complication later. So we've got, yeah, the thing I was saying is it's likely that this will go to the House of Lords or the Supreme Court, as it is now called, because as Lindsay Johnson points out here in his article, we're left in a situation where no one's satisfied. So the current position is an applicant has an enforceable right to an assessment under Section 189A. And a Section 189A assessment or failure to complete such an assessment is challengeable on public law grounds by judicial review. An assessment as to whether accommodation is suitable will automatically be unlawful if it's based on an unlawful assessment. An assessment as to whether accommodation is suitable, which is not based on any Section 1A, that's the crazy bit. If you did it, if you don't bother doing an assessment at all, that won't automatically make it unlawful. But if you do an unlawful assessment, and I'm not going to go into what the assessment would have to be unlawful, but maybe, but you see the crazy thing is that would be unlawful if you tried it but got it wrong. But if you didn't bother at all, then
I think there's still. I've just been looking at some LGSEO decisions to see how they look at this sort of thing, and whether this would change it. I don't know, but I think it would still be entirely open to be found to be maladministration. So if the council has a duty, so where there's no, yeah, the fact that there is a duty to carry out an assessment, that would be enough for the LGSEO to say that's maladministration. Then if it then leads to some sort of injustice, then there would be a compensation claim potentially on the back of it. I'm just looking at it as a case involving, I think this is, what is this, Hillingdon? Yeah, Hillingdon. Interesting case for a number of reasons. But it talks about if I read this paragraph, if that's not too burdensome. So
yeah, please do.
It's for the council to decide whether accommodation is suitable. However, the council has acknowledged that it did not have sufficient regard to the needs of Miss B's son when it offered interim accommodation. When it completed its suitability assessment, the council did not mention this, that her son needed to access toilet facilities easily in limited public transport journeys. So I think that's referring to a Section 189A assessment. I actually don't know for sure. I guess it could have been a subsequent thing. Then interestingly, the next paragraph down, which is a point for another discussion maybe, is just the LGSO saying that the fact that there was nothing better does not make the accommodation offered suitable, which is essentially a lot of council's arguments here is, well, there's nothing better, and the LGSO is saying, well, that's not the test. The test is it actually suitable for this household? So it's probably quite a useful one.
It's like that case in the disabled lady who got told, sorry, that's all there is. And do you remember that one? It was I forgot.
There's quite a few like that.
Yeah.
There's where I don't know if it's the same we're talking about. It's housing reviews were involved, and she had like some kind of bladder issue, and it was found to be. It was a question of like whether it was reasonable to continue to occupy or suitable, but it wasn't a happy conclusion to the case. I don't know if that's the one you're referring to.
Well, there was a happy conclusion in the one I'm thinking of, because she successfully challenged it. But here, I think we will have to go to Supreme Court because this is a mess. But the problem is, I mean, you know that I like to sort of go on about Section 189A assessments because I do see them as, in principle, a really good thing because it moves away from that sort of, let's just see if we can stop somebody being found entitled to be housed, and then if they get somewhere, they should be grateful, and we offer them something that's bad, and then they have to say why it's not suitable. But the problem is if the Supreme Court says yes, you've got to do a Section 189A assessment, and the consequence will be that any offer is invalid, we'll then get a watering down of the requirements of the Section 189A assessment. And you could see that in the earlier cases where they're saying, common sense says, if you do an assessment, there should be an assessment report which says what you've assessed. But then you get this thing saying, oh, well, you could do an assessment without even realizing you're doing it because you're doing your job properly when you make inquiries. And then you think, oh, if that's the case, then it's just waters it down beyond the point of it being much use. But more to follow on that one. Unless anyone wants to say anything more about housing needs assessments. This one is this one here. Oh, sorry, I'm looking at the added last week. The one I was going to talk about was the county court one. And this is another, let's see if I can make it a bit bigger. This is a strange case because it's sort of like lawyers going off on a sort of Mad Hatter's Tea Party to argue about sort of the minutiae of things. But what it concerned was the person brought a disrepair claim, as Core brought a disrepair claim against the council. Now, I'd forgotten this, so I've learned a useful thing. But if you have a license, then the stuff in the Landlord and Tenant Act 1985, and you know, as enhanced by the what's God, I always forget the name. But basically, the stuff that's in this book here doesn't apply to you if you're a licensee. You've got to be a tenant to have rights to have just to take action against the landlord for disrepair. So the the defence that Birmingham ran to this disrepair claim was, sorry, you're a licensee, so you haven't got any right to bring this action. And they won. But it went through a sort of torturous reasoning by the court, because there used to be a simple rule for housing lawyers to say whether somebody was a tenant or not, and that was whether they paid money and they had exclusive occupation. So you rented them somewhere which was basically their home, sort of common sense. But that was in the case of Street and Mountford, which is sort of what was a sort of touchstone for many years. But now in here, they're talking about, they've broken it down into the concept of exclusive occupation and exclusive possession. Which there is a difference, but I'm not going to go into it in too much detail. And so the problem I found was that I mean, it doesn't really, I think it will appeal this case just in order to get some clarity. But for lots of different reasons, they said this is a license and not a tenancy, which is a bit crazy. And one of the things in the license agreement, and this is where it's got wider application, is that they said it can't be a tenancy because the license agreement has provisions like the ones we talked about in that case of Beach the other week, where the guy refused an offer. But this had provisions like, we can move you to another property at very short notice. We can put other people in your property as well. And we can, what's the other one? You're not allowed to have visitors, that one as well. So the question would be, and this is Section 193 accommodation, it isn't Section 188. And so normally when you get the council accepting a duty, they'll say, oh, well, if we've given you accommodation, you can stay where you are for now, or for the force, you know, for now could be quite a long time. So they could be in this accommodation, which is subject to these conditions, And you think, well, is that suitable accommodation? I mean, how could it be suitable for somebody to have a home where your landlord can just move other people in, or move you out? It doesn't make sense. So there could be some new challenges on suitability if people look at the wording of their agreements. That if it says those things, I think you could challenge it, because no, it's not a home, it's not suitable, and it might be okay as 188 accommodation, but not as 193. But maybe somebody will correct me if I'm missing something there.
Can I just ask a really stupid
Yeah,
question about this?
no,
Because
no,
this is
no,
not
please
this
do. I'm
this is
sure
not
what
something I've got
happens.
experience with at all. But so the council accepts section 193. You're then in temporary accommodation. I can that be a tenancy? I've never known that to
Say
be
that again,
like.
please. Sorry.
So when a section 193 is accepted for someone, and let's say they're in the same property, they were under a license under and it was all kind of part of section 188, and then now the main duty is accepted. Are you telling me that it's common practice for councils to, kind of keep people in a tenancy, AST, I assume, whilst they're waiting to be housed properly down the line? Because I just, does that
Well,
not throw
that's.
up lots of issues
I
when it
mean,
comes to move them? Is that, I mean, it
no, it's
seems to
not.
be
Well, I'm
that's
not saying that. And an AST would actually be a step up from this. But this,
okay. So we're not talking about this. This wouldn't qualify as a.
no, an AST would be a
Okay.
tenancy, you see, as well. So Ms. Core would have been able to bring her disrepair claim. And that's another reason it can't be a suitable accommodation, because if you've got no rights to have property kept in this fair state. No, but what this is saying is that the council can put you in a licensed accommodation, or accommodation where you are a licensee and basically have next to no rights, at section 188, or even they could give you new accommodation under section 193. They could move you and say, oh, we're putting you in this new place under a license. In fact, this happened to one of my clients recently, and she got the usual sort of terms. She got upset, understandably, about being told she couldn't have visitors, or people to stay overnight and stuff. So something's got to be done about that. I think that, I mean, at the very least, the law should provide that if accommodation is provided past section 193 stage, it has to be a tenancy, in the sense that the occupant, has the rights that you'd normally associate with a tenancy, i.e., it could be a non-secure tenancy, so they could take you to court quicker than with an assured shorthold or an assured tenancy. But it should mean that you're not subject to summary, because then you've got all this problem of, God, it gets even more complicated, because if they turn up and say, if you're a licensee traditionally, and if you're in bed and breakfast or something, they can just say, oh, your booking ends tomorrow, you're out, and there's no court order, no bailiffs. Whereas if you're in a self-contained property, it's a bit more hazy. And there was a case which I did called CNZH, which was about whether people could turn up and evict you summarily, if you were in accommodation which was temporary accommodation, or whether the council had to get a court order. And it didn't make sense for the council just to be sending people around to throw people out in the street. Although, on the other hand, it did if you're running a temporary accommodation thing. You don't want to have to wait 4 months to get a possession order. And so what was held in CNZH was that somebody in section 188 accommodation isn't an occupier for the purposes of the Protection from Eviction Act, whereas they are if they've accepted a section 193 duty. But that isn't determinative of whether you're a tenant or a licensee. So it's horribly complicated, isn't it? And if you read this judgment, you get the feeling that it's, we're trying to piece together. They're trying to piece together a rule where Parliament should really make that clear, and even if it goes to the Court of Appeal or Supreme Court, it'll probably be horribly complicated there. So this is a pain. Anyone else want to talk about that?
No, just to say I'm massively confused by all as well. There's
No,
the questions come in
I am.
on the YouTube as well.
Yeah, yeah. I'm gonna. I'll take a break for this comment. Hang on. Let's see if I can just go to the comments page. Bear with me. So if I go to comments and then I think I need to bring that in there. Can anyone see that? It's a bit small. I'll make it bigger. Yep. So, can my friend take her landlord to court for doing nothing about the mold and damp in her flat that has ruined beds, bookcases, and some of her personal belongings? Thanks, guys. Does anyone else want to have a shot at that one?
I'm just looking through. I mean, it doesn't say what type of accommodation this is, whether it's kind of interim or temporary or permanent or whatever, settled. I'm just going to see if I can find anything in the LGSCO decision database to see if there's specific things. Because I think one thing I'm pretty sure about is you can take a case to the Ombudsman and they'll recommend an amount of money compensation, but then you can then go to court on the back of that almost as kind of that as evidence and then get more money.
Although,
because the LGSO doesn't offer, or the Housing Ombudsman doesn't kind of recommend that high payments, whereas the courts potentially would.
what I would say myself on this one is that presumably the fact that there's a landlord here, if you have a landlord, then you have a tenant. But so if you have a licensee, you have a licensor. But that's just lawyer speak, because basically people call it a landlord, whether it's a license usually. I mean, if it's a hotel, they won't call it a landlord. But if it's a house and you live there as a licensee, you'd still probably call them your landlord. So I think what we've just been talking about with Core here is that if the property is let on a license, it's more difficult to take the landlord to court for doing nothing. There may be other ways in which you can get round that. I haven't looked at whether licensees are excluded from all legislation and protection, but if they're excluded from Section 11 of the Landlord and Tenant Act 85, oh, we've got another, hang on. Katie has told us it's private rent permanent. So I will just come and say yes. The answer to that is yes, you can take your landlord to court. This is what you're describing is a sort of textbook outline of a disrepair case. That if the landlord has been asked to, if the landlord knows about the disrepair and hasn't done it, has notice of it and hasn't done anything about it, then you can take the landlord to court for two things. One would be to get the work done and get an order requiring the landlord to do the work, and the other would be to claim compensation for the loss of enjoyment of your home for having to live in a rubbish place, and also the things that you're describing there are described as special damages, things that you have to reach into your pocket to put right. So buying a new bed, bookcase, or personal belongings. So yeah, you could. It depends on how much, the bigger the claim, the more you could get a lawyer involved. If it's only been going on for a few weeks, though, you've got a problem that it's not going to amount to that much. But give it a go, because if you've got the more things you've got here, because the small claims limit in disrepair is the cost of the repair work's got to be over £1,000 to go out of the small claims. And I think £10,000 if it was just damages. I may be wrong on that. It could be 1,000, but I think it's 10,000. But the reason I'm going on about that is because small claims can be a good thing. If you want to take your landlord to court yourself without a lawyer, you might well want to do it in the small claims court, because then your landlord isn't going to be able to get their legal costs against you if they win. And there's another point. And that is, it's been years, can she get legal aid? Well, yeah, if it's been years and there's damp and mold, yeah, your damages are probably, your cost of the repair work's probably going to be more than £1,000, and the compensation could be more than that. And the test for legal aid is it's got to be a threat to the health of somebody in the household, and damp and mold is accepted as that. So I think that would be a case for legal aid, subject to your friend having financial eligibility. So if they've got an income, if they're on benefits like universal credit, they're on, that's a passported benefit, so they'll automatically get legal aid on income. And if they've got less than £8,000 savings, then they'll qualify. So yes, they could. And if you can't get legal aid, some solicitors, and I'm looking into doing this. I haven't generally done it very much. Can get do what's called no win, no fee agreements, and you can get insurance in case you get ordered to pay your landlord's costs if you lose. So I hope that answers your question, and congratulations. I think you're the first person that's left comments and questions on my live stream compared to Mike's. Oh, no, I've got a second question now. So I'm just going to put this one up from Roxy. Does will mean supported accommodation, which are often licensed? No friends over, no drinking, drugs. No, will doesn't actually mean that. What I mean is just anything that's well, it depends what's in the agreement. Ms. Kaur wasn't in supported accommodation or hostel or any of that. She was just in a property. And Mr. Beach, who we talked about before, who I think he had similar restrictions, was in a seaside hotel, which I suspect was out of season. It wasn't the sort of place we often talk about here, where it's a hostel and there's sort of people who are described as support workers or something kick you out at short notice. But it would apply to those people. But the question, when you're in a self-contained accommodation, you're in a legal grey area, because if I'm your landlord and I come to the door and say, right, I want you out, and you happen to be on the other side of the door with a Rottweiler and a family, I'm not gonna risk it to go and try and pull you out. And if I call the police, if the police are doing their job properly, they're going to say, look, you've got to go to court. We didn't become police officers to throw families out on the streets. Although you'd be surprised how often the police give bad advice in this type of situation. So I hope that answers the question. And so that's that. Katie's, you're very welcome. I hope this is useful. It's a thank you for putting it in the third person as well. I'm not saying it was about you, but it's easier. So to answer if it's like that. Now we talked about Norton, we talked about Core. Now the other one I wanted to talk about is this one here, Surrey County Council VR and BC. Now this concerns an area of law that we don't talk about that often, which is the Children Act. Well, I talk about the Children Act and terrible things I've seen social workers doing when they're supposed to be assessing migrant families who are excluded from mainstream housing. That's section 17 of the Children Act, but there's also section 20, which I'm not going to go into huge detail, but section 20 is where a child doesn't have anyone, nobody's able to look after them, and so they would get looked after by the local authority. And the important thing about section 20 accommodation is that if you're accommodated under section 20, and there's a sort of torturous formula for how long it's got to be, but let's just say you pass the audition for that, you're then entitled to aftercare services because you're treated as having been as a care leaver. So there's what this case here concerned was whether a child had been accommodated by the council or not, and therefore was entitled to be treated as a care leaver. And also, it was quite interesting, and I haven't read it, but I will do. There's quite a lot about when you should bring a claim for judicial review. Because if you're going to judicially review a council, there's a very strict time limit of 3 months. But the 3 months is deceptive because it says the actual rule is you've got to issue proceedings as soon as possible, and in any event, not more than 3 months. So it's possible that if you left it until 2 months and 3 weeks, the other side could say, oh, this wasn't as soon as possible. And I do believe that's what happened here. And it had been quite a long time since the actual events. So it's quite an interesting read. But if you manage this judgment, by the way, is 40 odd pages. Look at that.
Does the fact it was brought a year after, whatever, does that kind of then have like concrete negative impact for Law Stop? Do they kind of like have to pay fees or
No,
anything like that for that?
well,
Or
I'm not sure what the outcome was for laws in terms of the court saying this is, inappropriate. So I think there may have been some criticism, but I mean, the interesting thing with this is that Law Stop were the solicitors, but the barristers in this case were two of the best barristers in this area. And there's Daniel Clark of Doughty Street, who is excellent. I mean, I can't see that he would run something that was likely to get somebody into trouble. And Xu Xin Lu is really, really good. I mean, I've tried to get her on my cases quite a few times, and she's so in demand that it's like trying to book Elvis for your Christmas party or something while he was still alive. It's not really going to happen. But so I'm going to read it through. But if you bring a judicial review claim, and also the way you can get around the 3-month thing is if like in January 2024 the council made a decision to say X, and you think, oh dear, that's more than 3 months ago, I can't challenge that. But what you can do is send the council a letter saying, which is what happened here, saying, I'm inviting you to reconsider your decision from January, and here are the reasons. And if you don't, if you don't reconsider it, I'm going to judicially review you. Which then you've got your 3-month time limit from then. But I think in here the court said that was sort of not on. And certainly the council argued it. And they had, yes, of course, they had Catherine Rowlands, who is, I think, a sort of regular person on this show, because she gets she's doing so many of the leading cases. And in fact, I've put a link in the database to 2 articles she's written. This case has got such a lot in there that she's written this one. I'm not sure if this is the article or this is article 1. So we've got 2, and then we've got a third one to go. So I'm going to read those and come back. But I won't say much more about that now because it's I haven't read the judgment, so I'm not in a position to say very much. Whereas I did read Norton and I did read Core, but I must say I didn't feel any the wiser having done so, because sometimes you feel with these cases it's just like trying to sort of hold water in your hands when you and you think, well, this could have gone either way. The judge just stuck the law together and it doesn't make an awful lot of sense. But that's often what the law appears to be. So I think that is it. Oh, we got Cheeseface saying hello, Cheeseface, and I think that's probably about it for now. Unless anyone's got anything to add. Sorry, Mike, you said you wanted to mention something.
So we're it's rather last minute, but we're running a free webinar on Friday afternoon, 3:30 p.m. Me and Will and we're basically going through the homeless application flowchart I did like a year ago or so, because I can't think of a better way of actually doing a video about it, because I'm relying on people asking lots of good questions. So I'm just checking how many tickets are left. There's 30 places available, and we got put it up this morning, and there are 4 left. So you better be quick. If you go on Eventbrite and look for homelessness best practice, and you want to come along to it, then yeah, as I say, it'll be like an interactive Zoom meeting. It'll be recorded, but you won't be on the recording. You'll be off the recording. But I'm just going to we'll crunch through literally every single stage of the flow chart, and hopefully it will make sense to people, and you'll see how ridiculously convoluted it all is. But it should be helpful at some level anyway. So yeah, that's me.
Karis, did you want to add anything or say anything, or?
I would talk about, the looked after child.
Yes.
And the topic of where it comes into, sometimes it can do with parental consent, or it can be terminated with parental consent.
Being a looked after child under Section 20.
Yeah.
Hang on a sec. Yes, it can, can't it? Because you can, hang on. It's God, I'm sure how rusty I am. Let's just go through. Section 20 is where there's nobody available to look after the child, and the child
Sometimes
agrees.
they describe it as a voluntary duty of the
Yes.
council, don't they? Yeah.
So it'd be where there's. So sorry, I'm scrolled down. No, I'm not. Shall I? But I think the point as you're saying is that if a parent went to the council and said, "Look, I just can't look after this child right now," that would be housing them under Section 20. Whereas if they said, "We can't, we want to be housed together," or the child presented on their own, I think that would be under Section 17, because the child would be, quote, in need. God, you're so rusty. So yes, so the parent could come back and say, "I'm withdrawing the consent," and they should then give the child back, or the child would then go and live. But if the council didn't agree with that, they'd have to take the child into care through care proceedings. So sorry, I didn't let you finish the question.
I was just trying to establish like when and I don't think there's really that much case on it of when the parental consent terminates, the council coming in and saying no, they don't have to house them. I would just like to know more about this. Or am I reading the wrong?
Let's just check. Section 20 says every local authority shall provide accommodation for any child in need within their area who appears to them to require accommodation. So don't be put off by the reference to child in need, because the child who requires accommodation is homeless and therefore is in need, unless, correct me if I'm wrong, but it's sort of circular. The definition of in need is where your well-being or development is likely to be impaired without input from the council, or if you're disabled. A disabled child is automatically in need. So here are the three things. There's got to be no person who has parental responsibility for him. He has been lost or abandoned, and the person caring for him is prevented, whether or not permanently and for whatever reason, from providing him with suitable accommodation. So I guess what you'd have to, so the parent couldn't just go down there and say, I can't cope, I want you to look after the child and get them housed under Section 20. But they could abandon, I'm sorry, I shouldn't laugh about it, but they could just leave them at the office and say, well, if you're not going to help, I'm going. And I've had that before. I had to encourage a client to do that once because they kept saying, you've got somewhere suitable to stay. The housing department was saying, well, you're not homeless, you've got somewhere to stay. And she was saying, no, I'm not. I haven't got anywhere to stay. But they wouldn't believe her. So they were playing chicken. So she had to say to them, look, I'm not having another night on the bus with the child. I'm just leaving him at your office and you can house him because it's not fair. And took quite a lot of persuading. But by the time she got to the bottom of the stairs on the way out, they were sort of chasing her, saying, okay, we believe you. So I think that if the child, if the parent voluntarily wanted the child to be taken into care, I think they could say, if there was a reason they couldn't, I mean, prevented from, sorry, the person's, yeah, I mean, it's not even about being prevented from caring for them. So if you've got suitable accommodation where the child could live, then you can't sort of say, sorry, I'm having a breakdown, I can't cope. You'd have to go and ask them to house under Section 17, I think, and say the child's in need. So does that answer? So, and then if they then came back and said, I'm better now, they would then be able to say, well, could you carry out a new assessment and decide whether it's in the child's interest to come back with me? And then if they didn't do that, you could judicially review them, I think. But if they said, no, we're not giving you the child back, I think they'd have to, unless they could do an assessment. But if they did an assessment which said it's not in the child's best interest to go back with the parent, they'd have to do care proceedings, because otherwise they'd be sort of getting it through the back door, and it wouldn't be considered by a judge. Sorry if that doesn't make a lot of sense. But the main case law, which is interesting, and this is the sort of thing that happens, is that councils are desperate not to be seen to be looking after us, because you get it with 16, 17-year-olds. So a child will go to the council and say, please, can you give me accommodation? I haven't got anywhere to go. And the social worker will go ringing around all the family and say, do you want to see this child on the streets? And then somebody will say, no, I don't. So they'll say, well, I'm bringing him round to your house now, and you can look after him. And that's what happened in this case. And the judge at first instance said that because the social worker took the child to the house, they were sort of employing the family member as an agent, and therefore the child had been looked after by the council. But the Court of Appeal said, no, that's not right. But there's the whole history of, oh, yes, I did, oh, no, you didn't, sort of ridiculous situations. And then you get fights between, well, the housing department sometimes pick up children, which they shouldn't do, because you can't, all children under 18 should be housed under the Children Act, if I'm not mistaken. But then they'll say, oh, well, we didn't house you, housing did. So it's haven't come across too many of those. But if you want to wade your way through the 40 odd pages of this judgment, let's say, where's it gone? This judgment, then you will be wiser. I'm sure they cover all of these, the history of it. I mean, they've got a lot of pages to cover in there. So a couple more comments before we
But aren't they
finish.
supposed to approve? Sorry,
no, please go on.
aren't they supposed to approve? If they say by a local authority are supposed to approve a family member to be like a foster parent, they have to be approved.
Yeah, but they,
Yeah.
I don't think they don't
private
have
foster.
to, and this can be very bad, because in these cases where you're dealing with people with no recourse to public funds, which is a sort of testing ground for just how badly you can treat people and get away with it. What was often happening was that social workers would call up ex-partners of the mother, even where there'd been allegations of serious domestic violence, and see if they could persuade him to take the children without doing any assessment of whether he was suitable or not. And despite protests from the family, even the children say, we don't want to go with him. But they would say, oh, no, he says he's got a spare room in his house and you can go and stay there. So I don't think there's much. And the problem with these things as well is that most of the judges dealing with these Children Act cases in the High Court, as distinct from the Family Court, but most of these go to the Administrative Court. I mean, you're dealing with an awful lot of judges that sort of went to private schools and prep schools where they lived in terrible conditions, and so what's all the fuss about? I swear. So you've got some really awful situations there. But if you were lucky and got a family division judge, they would sort of get really angry if social workers were doing that sort of thing. But I don't think they had to do very much. They should, I mean, morally they should have done, and perhaps if you read the Code of Guidance as to how they should have been judging it, they should. But if they do an assessment and say, in our opinion, the father's all right, there's not much to hold them to account. So maybe we could have a session where we could talk about Children Act, because I think the Children Act and its application to homelessness is really interesting, and I've been really interested in it since 1994, I think, and thanks to the database I can just check that, because if we go to tags and we go to Children Act, is this showing on the screen? Yes, it is. Great. I'm not busily doing it where you can't see it. So Children Act 1989, and the very first case that I dealt with on this, oh, yes, it's not there. Hang on, let's just see. I'll type in the name. It was called, maybe I put it under section 17. The tagging isn't brilliant on this. Section 17, no, okay. Let's just have one chance. It might be because it's such an old case that that it's not in here. I'll try and put it in here. It's called Smith and North Avon District Council. And it was the first time that the courts actually said, yes, the Children Act gives the power and an obligation of children's services departments to house children and their families where the housing departments are refusing to do so. And what I will try and do next time is put that up there. So yeah, and as I say, I used to do a lot of Children Act Section 17 stuff, but I haven't done much lately. But I still get quite a lot of requests to take the cases on, but they seem to settle very quickly. But one of these days I'll get another big one, and I'll tell you more about it then, or the issues, not the case itself, maybe. So here's a question. Maybe you know the answer to this one, Karis. Oh no, not good evening from Cheeseface. Sorry, it's this one. Do any of you know if there are good solicitors around Southend, Essex? I just know that you're a bit closer to Southend than I am.
There is Duncan Lewis in Chelmsford, and you've got Steinberg Reed in Romford.
Ooh.
And they do the Grays area. But there is the Harp charity that could help, or there is Essex Legal Link. And Virgo Solicitors could also do Southend and Essex.
Yeah, bear in mind that if you want a solicitor nowadays, you don't have to have one locally. You can contact solicitors and do everything remotely. But the problem I've got here is that I can see that there are solicitors in, let's just say solicitors, Southend, legal aid, housing. Oh, there we go.
Assuming that you are looking for legal aid housing solicitor.
Yeah. There we go. There's this. You can do a Google search, but I'm afraid I can't tell you whether they're good or not. Obviously, the reviews suggest they are, but you know, it's easy to put up things that aren't necessarily true. I'm not saying that these guys have done that. So that's that question. But then we've got. Is that from? Yeah, I mean that's an answer. That did was that you, Mike? That Virgos can take cases from anywhere. Yeah, and we've got. I'll put a link on the. I don't know if it's on the channel. Let me just check. I think it might be on the not on the. If you go to the law channel, I'll definitely put it on here. But then the channel details. Oh yeah, if you go to the actual channel rather than this, and you go to the more information where it says about the channel, down at the bottom there's a link to the Virgo Solicitors new client form, which I can move up here. So if I move back over here, which is there. So yeah, so you can go online and fill that in, and that will enable us to decide whether we can help you or not, or help us towards deciding that. And that can be anybody anywhere in the country, as long as you've got internet access and you can sort of scan documents, which nowadays with a mobile phone you can do. Even I must do another mention that on a show, just so that people know how you can do that, because a lot of people don't realize that iPhones and Android phones now function as really good scanners. So I think I just put this question up and then, or this comment, which is, yeah, what a ridiculous this is. If the home was unsuitable, would the parents then not qualify as unable to provide suitable accommodation? Yeah, I mean, I think, yeah, if the that's the Section 20 business. So if they were living in some sort of shack, which wouldn't be safe for a child, then they could ask the council to house them under Section 20, I think. But if it was an okay place and they just didn't feel up to it, then they wouldn't, because it's the wording is that they're unable to provide suitable accommodation. And yes, about damp and mold. Yeah, that's there's a lot of that. So you could, I mean, sometimes with these cases, I mean, I had a case the other day of somebody saying that they'd been provided with temporary accommodation by the council, but it was in a terrible condition. And I mean, I don't know what people think, but one of the things they said was that there was somebody sort of seemed to be chain smoking in the room below theirs. And so there was smoke coming up the whole time. So it was a bit like they were sitting in a pub in 1995 or something. And she said that the children were getting migraines. And for me, who grew up in a household of smokers, and I'm fairly immune to it, but I mean, actually, it's a really serious problem, and it could be life-threatening. So I said, do you want to go and go and see your doctor, and then if the doctor gives confirmation that, I mean, not that they have to, but you could go and see Children's Services and get a social worker to come out, and if they come and smell all the smoke in there, you could be looking at asking them to do an assessment and saying it's not reasonable for these children to live here. But that sounds a bit petty, doesn't it? You think, oh, no social worker's going to come and do an assessment based on the smell of cigarettes. But I mean, I think you have to ask for the sky and let them tell you why you can't have it. But I'll let you know if she does go to social services. But most people, one of the problems with Children's Services is most people are terrified of having anything to do with them, because there's a sort of popular mythology that they're going to take your children into care, or they're going to be snooping on you and looking if you're a bad parent or not. And unfortunately, that isn't totally unrealistic. And social workers often, I'm sorry, I sound like I'm really hard on social workers today, but social workers do actually tell people that they're going to take the children into care, which they shouldn't do, because it's highly unprofessional to do that, because you shouldn't threaten to take a child into care unless you've got a good reason. Oh look, here's something nice. In my opinion, Virgo is excellent. I was fobbed off for 5 years and couldn't even get the council to take an application. 3 months with Virgo and I had interim accommodation. Oh, that's good. I'm sorry it took so long, given that it's a mandatory duty that you should have had straight away. But I'm pleased to hear that. And yeah, it is an uphill battle, isn't it? But you just have to keep sort of. The danger is, as I was saying last week, if you settle for anything less than what you should settle for, you sort of allow the system to continue to decay. So we have to keep on battling uphill. And on that happy note, I think we've reached an hour, and unless anyone's got anything they want to add, I will say thank you very much to Mike and Karis, and see you on Thursday. We're back on Mike's channel, and then Mike and me will be back on. Well, that's limited access, isn't it? Because unless you booked for it, but then we'll be
The
back.
recording will go up. So
sorry.
For those who don't get on, like, the recording will be up in a week or so.
Yeah. And what was I going to say? Yeah, please, if anybody, I should say the usual like and subscribe, but if you want to, if you've got any questions about anything, I'll try and put the link to the live, basically the fact that this is going live. I'll put it up there sooner this time. So if you've got any questions, just go to the website, go to the YouTube channel and stick the questions in there. And you can put quite long questions in, which you might find easier to do than waiting until we're going live and then sort of putting it more quickly. But remember, if you do, please don't give personal data and say it in the third person, even if it's about you. And hopefully see you and more people next time. So that's it for now then. Bye-bye.
See you later.